Fix this right here. All right, everyone, thank you so much for coming. My name is Laura Umetsu, and I am a former board member of NAMI Seattle, and I am pleased to welcome to you the two candidates for Seattle Municipal Court Judge Position 7, Nyjat Rose-Akins and Damon Shadid. We also have with us Dr. Becky Bay of Binnacle Psychiatry, who's going to be acting as moderator. So I'm going to go ahead and hand it over to you, Dr. Bay.
Welcome all. What we're talking about tonight is really the mental health diversion court and mental health in Washington State to some degree, although that's not really going to be our focus. And I'm going to jump right in there with the first question. And this is a really complicated question. So I'm going to start with the general question and then we'll go down into the details.
Okay.
So when and how does the mental health court become involved or become an option to the, I don't know what to call them, defendant?
Yeah, defendant or participant, yes.
Before, after they're charged, is an admission of a guilt necessary?
Okay. Is that my question? Okay. Well, the mental health court is structured in very specific ways that has evolved over time. Early on, I've been the judge in mental health court now for 4 years, but the Seattle Municipal Court Mental Health Court is the oldest municipal mental health court in the nation. We're very proud of that fact. Now, when we discovered there were a lot of people who had mental health issues that were repeatedly cycling through the criminal legal system, the first thing we did was we created a flag for those people. And so instead of being processed through the jail calendar, mental health flags were processed through the mental health court calendar. So every day I see all of those individuals, I get to know them, I get to know what their barriers are and what their needs are. The first thing you have to figure out is whether or not they're competent to proceed, whether or not they're going to raise competency or not. And then if they are competent to proceed, then they have the option of entering mental health court or opting out of mental health court. If they opt in, we create a release plan that is individualized to that person. If they opt out, they're prosecuted in mainstream court. Just very quickly, there are two different aspects. When they opt in, they go on conditions of release. The conditions of release are to make sure that they're capable of participating in the mental health programming. Then if they do reach a disposition, then they go forward. So they don't necessarily have to plead guilty. Usually we use contracts called dispositional continuances that don't involve a conviction. I'll stop there. There's a lot more to say about it, but I'll stop there.
Oh, same question? Well, I agree with what Judge Shadid just stated. As far as I know, because I've been an attorney participating with mental health court rather than being a judge adjudicating over mental health court. So my understanding is pretty much what Judge Shadid just stated in the sense of the process. So to be clear, participants do not have to enter a plea of guilty in order to enter into conditions of release. It's usually individuals then get an opportunity to then engage in treatment and or obtain an evaluation to see exactly what, to basically see what exactly their issues are or what their mental health struggles may be to figure out a plan. And my understanding is that mental health court is usually a 2-year comprehensive plan to work with that individual to ensure that he or she does not continue to commit criminal law violations, because the thought is that their mental condition or that their mental condition is a part of why they are acting out criminally.
So a follow-up on that, if a defendant consents to be under the authority of the court, what does that mean? What role does the court then play in determining treatment specifically? And I can repeat parts of this because I know it's very complicated. Do they retain, are you ordering them to take a specific medication? Are you ordering them to see a specific clinic, which would mean a specific psychiatrist? How do you work into that, the concept of informed consent, both on the part of the treater or the provider or doctor and the part of the patient? What is the role of the court when you intervene in treatment?
All right, I'm gonna give you guys more than 2 minutes because that was a multi-part question. And I'm gonna be fair and start with Nyjat.
Okay, thank you.
Go over it again.
So because mental health court is a therapeutic court, the point is to try and understand what are the issues facing this specific participant. So in regards to what is the role that the court plays, the court is not a subject matter expert in regards to mental health, right? The judge is a lawyer, the defendant or the participant is represented by an attorney, and the state is represented by the prosecution. So because it is a therapeutic court, the defense, the prosecution, as well as social service providers and other practitioners who are the experts are in a room to talk through what is the plan for this specific individual. You have to look at that individual's criminal history, all of those things. So what the court specifically can do is be the entity that orders this individual to then continue on with their treatment or orders them to obtain an evaluation. I don't think the court can necessarily order an individual to go to this specific person. I think it is more about what social service providers are involved and what the court jail release plan and social clinicians and social workers, that's the word I'm looking for, will explain what the options are for this specific participant. So I believe the participant is still in control because they can still choose not to participate in mental health court. They can choose to say, I do not want to go forward with this plan, and that is their prerogative, which is why mental health court is a therapeutic process where we allow individuals to be a part of the process. However, one more minute? Oh, so that we allow them to be a part of the process. So from an informed consent standpoint, they still maintain that. However, the court, if the court is setting conditions of the release, the court can order that an individual obtain an evaluation from X place and continue on with treatment if he or she already has a provider and or a doctor. So yes, the court is the entity that will order the individual to continue on with treatment. However, I believe the individual still would have informed consent to say whether or not they don't want to see this doctor. At that point, I think there is a discussion with defense and prosecution to decide whether or not a new evaluation is necessary and whether or not a new treatment provider may be necessary to better fit that person's needs.
So the mental health court, for the past 4 years, I've concentrated on really developing a sense of community in the court. We are a therapeutic court, which means we take a team approach. A judge is part of the team, the prosecutor is part of the team, the defense attorneys are part of the team. They all have different roles, but they are working together to try to figure out what the best path forward is. But the most important part of the team early on is our court clinician. And our court clinician is a third party. Her third party organization is Jail Health Services. However, she's completely independent. And she is an expert. She assesses the people. She develops the original conditions of release and the release plan. And then the participant in the release plan is expected to very much have a role in what they want to do and how they want to do it. However, The aspects of that release plan are always going to involve substance use treatment if they need it, and mental health treatment always, because you have to have some sort of diagnosis in order to enter the court. I've also developed a lot of harm reduction strategies in mental health court. When I entered mental health court, it was dying on the vine. The recommendations were too harsh. The programming was too stringent, and people just weren't opting in. That wasn't happening. So what I did was I negotiated with the city attorney's office to redo the recommendations to make it more interesting for people to enter court. The second thing I did is I changed the way we dealt with abstinence violations. And the years before I came onto the bench, abstinence violations were always met with jail. This is not something that I thought was helping people in the treatment. Jail actually hurts treatment. And so what I did was, if the person comes in, is honest about it and is still willing to engage with treatment, then they get a pat on the back, because it's hard to be honest about your use. It's hard to pick yourself up off the ground when you stumble, but jail is just going to make that worse. And so that has really developed an enormous amount of trust. Now, the way mental health court is structured, the judge has a 2-year obligation to be in mental health court. I've been there for 4 years. And the reason for that is so that I can become familiar with the individuals that are coming before me. We also have staff attorneys, defense attorneys, who have been working there for years and years, who also know the people, and staff prosecutors. So there is a very tight community in mental health court. We're having a Christmas party together in December. I mean, we really get along very, very well. And I think that participants in the court really see that. But there's so much more I could say, but I'm out of time, so I'll go ahead and stop there.
So, the mental health clinician, as you described them, what is their qualification?
Our mental health clinician is a degreed professional in mental health. I believe she has a bachelor's, and she's been working with jail health services for years. And so the beauty of the clinician is that the clinician has access to documents that the court does not and should not have, because everything that I consider has to be public record. But she can consider private confidential records if the person has been civilly committed in the past or something like that. She can consider that in her analysis without making that public record. So it's crucial to have a third-party clinician at that stage in the proceedings.
Thank you. And because you asked the qualifying question to Judge Shadid, I'm going to give Nyjat a chance to also comment.
On the clinician, I will have to defer to Judge Shadid on that perspective. He has been the mental health court judge for 4 years. As I said, as an attorney working in mental health court, there was definitely a separate a clinician, I guess we can call her, that would work outside of the prosecutor's office and or the defense office to provide a different perspective. So my understanding was that individual was a part of maybe like probation in the mental health court side.
Do you believe that the participant should be allowed to say, I don't like my provider? My concern here is that I've had patients ordered to see me. I was not necessarily consented in the process, which I found quite shocking. And the second question there is, what if the patient doesn't want to do something that I think is essential? I'm only one psychiatrist. I'm certainly not an elected judge. How do we deal with that issue? How do we allow them to remain in the court system without becoming easily coerced by persons who may not see the consent as essential if they're mentally ill and I know better?
Nyjat, I'll let you go first.
Okay.
2 minutes.
So that is a great question, and I can speak to that from the attorney perspective, seeing individuals who come in and say they're not getting along with their psychiatrist or their clinician, or they don't like this particular provider. And it happens. And I think just like any of us, you know, sometimes you may go to see a counselor and maybe you just don't gel. It's human nature. It's what happens. However, I've seen it also where someone is on maybe their third and they're like, we're not getting along and this and that. So I think at that point, I think one, if someone is not having a good relationship, or maybe it's just not a good fit, I think the court definitely should consider that and allow for a new evaluation and allow for defense, the city to really have a discussion to see maybe if there's something else going on. But I think obtaining another evaluation or maybe providing another entity to allow that person to serve this individual is, I think it's the right thing to do. Because yeah, we're all people, and you know, sometimes we make better relationships with others than that. So yes, I think an individual or participant should have the ability to at least get another evaluation or change treatment providers if things are not working. What was the other part of the question? Was that it?
Well, the other part of the question is, how are you consenting with providers?
How are you?
Yes, I've had patients referred to me without, where I received, the patient walked in and handed me court papers with my name in it.
Oh, and you had never provided any service to that individual beforehand?
No. And I think the answer is that was an error on the part of the
Okay,
court.
yeah.
I just wanted to bring it up because it was rather odd.
Yes, I don't think the court can force a provider to engage in treating someone. I think it definitely needs to be a mutual decision. I don't think that's right, that the court can force that upon you. Now, it's one thing if you've already provided service to this individual and you have treated this individual, so you do have information about this individual. So I think that's one thing, but yeah, if you've never seen that person before, I don't think that's appropriate.
Well, I certainly agree with that. As far as the providers go, what I will say is that the mental health treatment system in Washington and really countrywide is a mess. There's a lot of bad treatment out there. There's a lot of treatment that is religious based that might work for some people. There's a lot that is so focused on 12-step abstinence based that they will turn away people using vital medication assisted therapies like Suboxone and methadone. There's just a lot of providers who don't mesh with certain defendants. And one of the very, very important jobs of the clinician is to get a good match. That is one of the things. Now, the Affordable Care Act has been an absolute game changer because it now covers mental health. And in Washington, we use Apple Care. So one of the first things we'll do with someone who comes into us is we'll sign them up for Apple Care. I mean, just right out the door. Once they're signed up for Apple Care, then we can start exploring. There's a lot of clinics that have walk-in appointments. That's useful for some. Others, we make the appointment for them and send them there to get their appointment. It just depends on really, we have to meet the participant where they are. And we have to understand how much hand-holding they're going to need and how to get them through that. But I'll tell you, in the last 4 years, we've had a lot of people who are already somewhat engaged with the system because the Affordable Care Act has made mental health treatment more available to so many people that we're starting to see a lot more connection than we did in the past in the community. And that's been really great. But as far as being able to change providers, this happens all the time. And this is okay. The main thing that's a concern to me is the medications that they're on. And I very much encourage participants never just to quit taking medications. If it's not working for them, go to their doctor and get their medications adjusted. Don't just quit taking them. And that's why in mental health court cases, it's so important that we check in with the participant repeatedly, both our probation department and our court.
So Michael Bay, Canadian expert on consent and mental health law, says that the mental health court judge must balance the civil liberties of the individual, their autonomy, and the role of the state to protect the patient and the community. do you believe that in Washington State, the current system for determining involuntary holds is working? And if not, what do you believe needs to be fixed?
So to be clear, we do not do involuntary hold court. That's a superior court matter, and we are working at the municipal court. But I do have an anecdote that I would like to tell you about why I think the civil commitment hold is failing so badly. So we have a lot of people who come into mental health court who have been repeatedly found to not be able to proceed. They do not understand the nature and consequences of the proceedings. They can't assist their attorney, and so they can't be prosecuted by the city or the state. And in those cases, those people many times are released onto the street. I had one defendant who came in. His thing was that he liked to assault, he tended to assault people at bus stops. He would walk up to a stranger at a bus stop, punch them straight in the face, and then he would get arrested for it. He would be arrested. We would hold him in jail for 2 weeks while he was being evaluated. He was found not able to proceed, so I referred him to civil commitments. It's called a designated crisis responder. The designated crisis responder interviewed him, let him go onto the street, where a week later he assaulted someone else at a bus stop. This happened 3 times. On the fourth time, the man tried to throw a woman off the bridge and almost killed her. He had never been civilly detained that entire time. Now, is it the fault of the designated crisis responders? You can't really just blame them. We don't have enough beds in Washington. The jail has turned into our biggest mental health facility, which it's not equipped to do, and we don't have enough respite beds and mental health beds to help all of these people who desperately need help, and it is endangering the public. And that anecdote that I gave you, it does not stand alone, and so it's a very concerning that we don't have enough facilities to help everybody that needs help.
I agree 100% with what Judge Shadid just stated. I've seen it on the other end as well, working with the police department and seeing individuals who may have, they are not necessarily committing a crime, but they're in crisis, and people call and they're taken to Harborview or usually Harborview, and the standard is very high, rightfully so. However, it does miss some individuals who maybe are not at that moment eminently, in danger of committing an offense that is a danger to themselves or others. However, when they get released back out in the street, because mental health is fluid, moments later, they may be engaging in that crisis behavior again. And because there are not enough beds, because the law is what it is, and the law on the books it's very clear in regards to what providers or mental health professionals can do. So, you do have to follow that. However, it does miss a large group of people who are in that gap that can't get committed because there's not enough beds, but then unfortunately get released out into the street because there's not enough beds. So I think part of it is it's a legislative thing, but also I think from a community perspective, we can really maybe try and collaborate to a place where we can have a lot of different social service providers, nonprofits, to really work better with the jail and the hospital, so that someone can maybe be released to a place that can monitor them for 24 hours or really just help them. But it is a woefully broken system that we just do a disservice to a number of mentally ill individuals.
If I get another minute on that as well.
I will give you another minute.
Sure, great. One thing that has been the focus of my work in mental health court is there is a serious gap when someone is found not able to proceed, but they're not detained by the civil authorities. This is a gaping hole in our mental health court system. One of the programs that we've instituted over the past 4 years is we've started working with a program called LINC, L-I-N-C. And LINC is for True Blood class members, people who have been found not able to proceed in the past. They're booked into jail, they're not able to proceed, But instead of holding them in jail for 2 weeks and waiting for that evaluation to come, we refer them to LINC, where they're given a respite bed, where they're stabilized in the community, and if they're willing to work with LINC, the LINC prosecutor in the city's attorney's office will dismiss that case. This is a pilot program. It's not big enough yet, but this is the kind of thing that when you're talking about community engagement, that's the kind we need more of that.
I have no additional response.
So I have a follow-up question. It sounded like when you were talking, you feel that the balance in Washington State is a little bit tipped toward the
The participant?
not just the participant, but the participants' choices versus the needs of the community or our perception, that the patient's perception, that's my word, is weighed more heavily, and what they want is weighed more heavily perhaps than you believe that either their own good or the community good is. So would you tip those scales a little bit differently?
Would I tip those? So
Was that clear? I'm sorry.
yeah, no, that is very clear. And I am going to agree with your summary that I do believe that the laws as written do tip towards the individual. And I think rightfully so, because if you want to take away someone's liberties, or you want to say someone needs to be civilly committed, that burden needs to be very high. So yes, I do believe it does tip in favor of the individual and that individual's rights. I do think from a community perspective that, you know, something I was thinking through, and even I kind of brought up a second ago, in the sense of that group of individuals who are not considered gravely ill to be civilly committed and are not necessarily in custody for committing a dangerous, violent offense, that we do a disservice to those individuals. So I would like, and I think the answer could be something from the legislature, in the sense of saying, okay, you've been, you know, released and detained for, you know, an evaluation and need to be seen by a mental health professional before you're released. But with those individuals, maybe we have another stopgap where they can go to a place, as Judge Shadid said, like a respite bed, or you know, I learned about this fantastic organization called Transitional Resources that deals with mentally ill individuals. And I'm like, we need more of those types of places to really help serve that gap.
So I hope I answered the question that you're asking, but if a person does not feel empowered in their treatment program, they are not going to succeed in their treatment program. And so, you know, part of harm reduction philosophies is to make sure that the participant feels that they are making the right choices in their own treatment. And so what I have found is if I force someone into something they're not ready to do, they will not do it. And, you know, sometimes I will say, maybe this isn't a good fit right now, let's come back when you're ready to engage more. Other times they say, okay, Judge Shadid, I'll give it a try. But, you know, one example of it is, you know, we used to have a zero tolerance policy for marijuana. Well, I had a person who had been addicted to heroin, and he was on medication-assisted therapy, and he smoked marijuana, and it helped with his cravings. And so I worked with him. I said, okay, you can smoke your marijuana. We're going to drug test you. We're going to see what's going on. And then very slowly, as we gained trust with each other, we were able to start decreasing his use. I had him start journaling. He would bring his journals to court every single time. He'd give them to me. I'd read them. And it was just, it was a way to bring someone there slowly. Whereas if I had used a hammer, it wouldn't have worked, and he probably would have relapsed on heroin. So it is really a case-by-case basis, but I do believe in empowering the participant whenever I can. That's all I have to say. Thank you.
when you use the term therapeutic jurisprudence, that implies that the court is a therapeutic court. What makes it therapeutic? You've answered some of this, but not the following component. What special training do you believe judges who practice therapeutic jurisprudence should have? I'll start with you, Judge.
Well, let me be very honest from the start. Judges are not given enough training on this. Judicial College does not prepare you for it. You get one class on it. The attorneys who have worked in therapeutic courts do better as judges in therapeutic courts, that's for sure. But a lot of this is a temperament issue. A lot of this is a demeanor issue for the judge. And there are certain judges, for instance, there was one pro tem we had to say, you can't be in mental health court, you're great, you're efficient, but you do not have the temperament to be in mental health court, because mental health court takes patience, it takes understanding, it takes the ability to take longer periods of time with any one individual in order to make sure that person is feeling heard when they may be rambling for 15 minutes. And so it is difficult. What I did when I came into mental health court is I gathered the team together, both individually and as a team. I had repeated meetings with them, with the prosecutors, with the defense counsel, with the clinician. I asked them their experiences. I asked them how we could streamline the court to make it better. I consistently asked them for feedback on my decisions and if they think that I'm being fair. We have our participants in the court fill out a survey and they can judge, how did the judge do? How did the defense do? How did the prosecution do? And that feedback is really crucial. But at the end of the day, the real proof that's in the pudding is, does the person exit the criminal legal system? And what I'm proud to say is that most graduates of mental health court, the vast majority, we don't see them again.
So therapeutic jurisprudence, the way I look at that is interdisciplinary collaboration. So we're bringing in, unlike, the traditional trial track here, we all are talking through this individual's case to see how can we better serve this person, or how can we help this person not commit criminal offenses. So that is when I think of it's working together to figure out what is the proper sauce that's really going to help this person be better, and better is, maybe being on their meds, getting treatment, and not committing criminal offenses. In regards to training as a prosecutor, I did go to, forums, but like continuing legal education on mental health. And, when I started out at the city attorney's office, that was my first, that's where I first started out, was in the specialty court. So I started in the community court and mental health court. So, but it isn't enough. And I think, for myself, I learned from a lot of the older prosecutors who had been in mental health court for very, very long, and from the defense attorneys that, as Judge Shadid said, there are attorneys that are in that court for a very long time for a good reason, because you want to make sure that people understand the individuals that are coming through the court. And because it is a therapeutic court, you do have to gain some trust. And even though as a prosecutor, I may not necessarily have any one-on-one time with the individual, but just speaking with the defense attorney, speaking with the clinicians, you really do get a better picture as to what those individuals are dealing with.
So, and this is related to some of what was in your position statement, mostly with regard to medication treatment in the jail. So here's the question. When you advocate for patients in jail to receive medications, what does that really mean? Is that any medicine they want? Is it any medicine they've been on from any community provider? And how do you work with the jail providers to both get the patients what they need and to respect their professional autonomy? Definitely a question for them.
All right, we'll start with Judge Shadid and I'll let Nyjat respond.
So one of the first things I did when I was assigned to mental health court was I called jail health services, and at the time, jail health services was not in the clinician role, and I asked them very specific questions. And the most important thing I wanted to know is, are they inducting people? Are they starting people on different medications, or are they simply continuing existing prescriptions? And the jail health services at the time was only giving people the prescriptions that they came into the jail with. Now, early on in my career, before I went to mental health court, I started the program to try to address the heroin epidemic. And the best tools we have for heroin are Suboxone and methadone. Suboxone is especially good because it can be provided. It's not quite as chronic as methadone. You don't have to use it every day, so on and so forth. And so I worked with jail health services where at first they wouldn't do it at all. Then they started allowing it for people who already had a prescription for it. And then finally, we were able to get them to start inducting people on Suboxone. This was this is a game changer for many of my clients. One of the continuing frustrations for municipal court judges is that the King County Jail is a completely separate entity under completely separate jurisprudence. And so even if I order them to do something, a lot of the times they won't do it. And so this kind of collaboration that I've worked with jail health services hand in glove for the past 4 years, gain their trust and encourage them to think outside the box and actually start treating people instead of just sort of maintaining baseline. I think it's been a real game changer for a lot of the participants in my court. I'm very proud of the work I've done with them.
So medication treatment in jail, I absolutely believe that individuals who have medications coming into the jail should absolutely be able to have access to that. If they are receiving a new evaluation, if there's an evaluation that's happening while they are in custody and that evaluation says they need XYZ medications, I absolutely believe that it is imperative that the jail get them those medications, because that is, especially if the thought is that this individual needs to be stabilized, if they're in crisis, all those things. And if we are going to keep them in custody, then we need to do everything in our power to ensure that they are getting the medication that they need, and that a provider who has seen them and evaluated them say, this is what they need. So I am a firm believer that people in jail need to be able to get the medications that they need. Should it be a medication that they want? I believe it needs to be something that has been prescribed and or there is a new evaluation that said this is what they need, but just them saying, hey, this is what I have, I think that needs to be vetted and to make sure that they're getting the proper medication and we're not just giving them what they say they want and then there's a whole nother issue with that. Yes, and I think the King County Jail could definitely do better. Reading up on other jails, I believe Spokane Jail has like this whole mental health unit or wing, and I'm like, how does King County, who, we're in one of the richest cities, and we don't provide the same level of service.
Could I just add to that? It's not really a rebuttal or anything.
Sure. People amount of time.
Sure. 3 things that could make the jail better. We need to triple jail health services. They need to be able to prescribe medications right there. They need to be able to do evaluations in the jail for both mental health and substance use treatment. And we need to, by a factor of 10 to 20, need to expand inpatient beds that are reserved for people who are being held in jail, who then get stabilized and are able to go to an inpatient bed. Those are just 3 simple but expensive solutions that we can do to make the King County job better.
I have nothing additional to add.
Oh, okay.
And I have lots of questions I could ask, but I'm not sure that it's a good use of your time. such as what do we do with people with attention? Let me ask my question. What do we do with people with attention deficit disorder? There's currently a policy that I believe is also in King County Jail. It was a year ago when I had a patient who I evaluated carefully, tested, who had very bad ADD, and the jail does not give ADD medications. What do we do with people who need a stimulant in order to quiet their brain so they can participate in court, so they can assist their attorney, so they can be safe, not antagonize people, et cetera, et cetera? I mean, ADD in adults is a recognized diagnosis. The jail doesn't treat it, having been a jail doc for a lot of pretty good reasons, but there are ways around that. What do we do to meet those needs in the jail?
That is a great question. Can I just, oh, well, I don't know if you're going to me
Yeah,
first.
go ahead,
Okay.
go ahead.
I just, since you said that you were a jail doc and you said there were very good reasons to not prescribe, can you tell me what those reasons are?
Without grossing anybody out, it's hard. There are issues of coercion. So
That the doctor is forcing the individual to take it?
that when they go back to the unit, they could be coerced to give up the medication, even if someone watched them swallow it. And I have had that happen to patients.
Wow, okay, that's fascinating.
It's gross, I'm sorry.
Yeah, no, I mean that it's, we're all adults here. But I don't like to hear that, because at the end of the day, if a clinician, if a mental health professional, if a doctor in the jail is saying this is what this individual needs, I don't think it's appropriate that they cannot get that medicine. Because if we're saying that's going to help stabilize them, that's going to help them not act out, it's going to be a benefit probably to everyone in the jail if this person is able to obtain the medicines that they need. So I think that even though there are some issues, there's always going to be, nothing's ever going to be foolproof. So at the end of the day, I think what would need to happen would be education, that we really need to educate the jail, educate the jail staff, and really from a collaborative standpoint, really sit down and have a talk to say, this makes no sense. There are a number of people who need this sort of medicine. And if this person is stabilized on this medicine, you know, this person could be in a better place. So I've never heard that before. I've heard other things where maybe people are unable to get certain types of medicine, but I didn't know if it was an issue based on the fact that that person may not have had an up-to-date prescription or something like that. But I think the thing for this would be educating the powers that be and the individuals who make those decisions to say, we're not going to do this, and to really have a really straightforward conversation that this is just, we need to better serve the individuals who we are choosing to hold in custody. That's it.
All right, thank you.
The Adderall issue is actually really similar to what I went through with the Suboxone issue, because Suboxone is specifically made that if you crunch it up, it mixes in naloxone with the buprenorphine and makes it not work to get high. But it doesn't make sense to pay for a name brand when you can get buprenorphine for 10 times less. And so that's what they're using in the gels. It does not have the naloxone component to it. And so how do you?
So Suboxone is a medication that is a combination of buprenorphine, which mimics an opioid but does not make you high. And the naloxone actually reverses it and can cause you to go into withdrawals if you've been using opioids.
Exactly.
All right,
I'm sorry.
Exactly.
Don't worry, you can move anytime.
Yeah.
Not a problem.
I'm sorry, I don't know if people know.
And so they said, you know, we can't do it. We can't be giving this drug to people. But then, you know, they switched up, like we talked about it, and we said, okay, what if we do a sublingual tab? And, you know, watch the person while they take it, because as soon as that goes in your mouth, it's gone, and you can't really recycle it. And the same goes for Adderall. There are safe ways of doing it. There are safe ways of prescribing these medications, and they need to do it. The jail health staff is very understaffed, very underfunded. And, you know, in general, I advocate for the jail to be a more therapeutic and a less carceral institution. And that means putting money where it helps, which is jail health services. Because I will tell you right now, they are trying very hard. And a lot of people like to beat up on jail health services for their inadequacies, but they are doing a lot with what they have. And I have a lot of respect for the director and for the work that she's trying to do there. But it could be better, and it's going to take more money.
So we have gone through very quickly the questions that we had, or at least some facsimile thereof. Do we have any community member questions yet?
Vince, are you there? Can you hear us?
She's on mute.
Yeah. So far, we have one question from Diana. I imagine Seattle's homelessness crisis makes it more difficult for houseless defendants to follow through with their mental health programs. How has the homelessness crisis affected mental health court outcomes? Have your experiences in mental health court given you insights into what Seattle should do better for our homeless neighbors?
Well, I guess that question is very specific to what Judge Shadid may be seeing in mental health court currently, given the houseless crisis. So I can't truly answer that because I don't necessarily adjudicate over mental health court. I can speak to, I do advise on homelessness issues for the city, and I do participate in meetings in regards to housing and funding that population from the city attorney perspective. And from those meetings, it is very clear that a number, not all, but individuals who are homeless, especially downtown, are suffering from maybe either mental illness brought on or further exacerbated by their alcohol and drug use. And I think the city is cognizant of that, and which is why they're partnered with LEAD and REACH and those organizations to really try and have better contact with those individuals, because a lot are, for the downtown ones specifically, where individuals can maybe be found and have case management and caseworkers to really assist them, especially if they are committing crimes within Seattle. So from my perspective, I know that the city has been working to engage with more provider services, case management, to really assist individuals to navigate some of the cases that they may have, but because they are houseless and maybe engaging in criminal behavior.
The first and most important thing is to get people housing and to get them stabilized enough to where they can follow through with treatment. If you are homeless on the street with the barriers that are involved with that, just getting by day to day is like working a full-time job or more. And then to tack onto that 2 or 3 appointments a week, it is very overwhelming for a lot of people. And so it's very important when we're in the conditions of release process of the court to get that person stabilized, to get that person housed, even before we get them into treatment. So we try to work with shelter beds. One of the biggest losses of mental health court was right before I took the bench, our funding for housing, for dedicated mental health court housing, was cut as part of the reductions that we went through. And so we lost 10 housing units that we had as transitional housing for people to go through. The city council insisted that we have put everybody onto the uniform housing questionnaire that they do. It takes about 4 hours to fill out, and then wait in line to get housed. That has been very detrimental, even though people with mental health issues are given some priority for housing. There's not enough, because you can't just put someone with those profound barriers into just any house. You need to have wraparound services, you need to have medication management, you need to have on-site services. And so we work with DESC, Clement Housing, like all these community partners to try to place these people into a housing unit. And we really, really aggressively attack that in the conditions of release part of the court, because I'm sorry, many times it is too much to ask a homeless person to be fully engaged in both mental health treatment and substance use treatment. Sometimes they just need that level of stabilization to stand on before they can jump or fly.
And I think you already answered this question, but I'm going to ask it to make it explicit. So the mental health court does not maintain or have access to basic services for individuals who are being court ordered. In other words, you can't court order someone into intensive outpatient psychiatric services or intensive outpatient addiction treatment and give them a place to stay, because you do not have primary access to any residential beds.
Yeah, that is correct. So we don't, the whole point of the clinician is the clinician first and foremost needs to make a plan that is going to be safe for both the participant and the community, because a lot of the people coming to mental health court have committed violent crimes. And so she's going to be working with them very intensively in the first few weeks to try to get them housed, try to get them connected to the right services. And so those first couple of weeks are absolutely crucial. Some people have to wait in jail for a release plan to develop. Some people are released immediately because they already have enough services, or the judge believes that they are not a danger to the community and can be out while we work with them. So it's very much a triage system that we're using. But the short answer to your question is we do not have dedicated housing anymore. And it's something I'm working with council members Juarez and Andrew Lewis on in order to get, but we still have not been able to get that funding.
Right, and do you have anything to add to that, Nyjat?
No, I believe, as Judge Shadid said, there are no dedicated, the mental health court doesn't necessarily have the beds or whatever have you, and we have to work with outside entities to provide those services. So I think as we, are coming out of COVID and are building out, infrastructure, we definitely need to create a better infrastructure to allow for that. And I think with, the mayor putting forward all of these loan housing and all these other initiatives that are being stood up, there's tiny home villages being built, all this capacity. I think we just need to do a better job of collaborating and partnering to make sure that we understand what is all out there, because there's so many different places over here, that place over there. And as a city, we do a very good job of really having a one-stop shop, like, okay, if this, then that, if that. And even though we do, but I think we miss a lot by being very siloed. So I think we definitely need to do a better job of really having a cohesive infrastructure that we can immediately go to and be able to better serve people in that fashion.
So I'm going to throw something out here because I'm astonished. Fundamentally, the city is not prioritizing these individuals, therefore the jail again becomes the only place to keep them. If people are staying in jail because there is no option for housing them that is safe, this is in effect, obviously this is not something that a judge could manage on their own, but this is a deficit in our city that we're not seeing this and giving this priority. And I'm sure that makes your job and the job you're hoping to do much, much more difficult.
It is absolutely true, and it is tremendously frustrating. But let me say that I do also understand the complexity of housing. For each unit you prioritize for someone in the jail, you may be taking away a unit for a single mother with a baby. And so I get it. I get that it's hard. But I don't think it's too much to ask to have a small number, 10 or so, dedicated housing units for mental health court. I don't think that's too much to ask. I do think that that would be a good priority for the city that would allow our streets to be safer and for participants to get better care.
And again, because I do advise on a lot of the encampment issues in the city, generally speaking, when the city is doing a removal, all the individuals that are, let's say, Woodland Park, who are at Woodland Park, are talked to, met with, and will be offered some form of shelter. So I definitely think we have capacity. We just need to create a better mechanism to ensure that, because I believe there's probably lots of overlap. So individuals who may have just been in jail, but now are camped out in Woodland Park, we could have potentially have, you know, provided this service to maybe have them released straight into their tiny home. So again, I think we are so siloed that we don't necessarily see the big picture to really better serve those individuals who are houseless. But I definitely think when we do encampment removals, those individuals are offered tiny homes, whatever the city has available for housing at that time. So I think we could potentially do the same for individuals who are being released from jail.
And we have was somebody talking? Okay, we have a question from the chat. Is there a way for cases to move from regular court to mental health court, and can court-appointed attorneys ask the judge for a change of venue?
Oh, sure, all the time. It's called a mental health court look-see, and it happens all the time. So most people, we already know them. We already have flags. We already know to bring them through the system. But when someone new comes through, we absolutely have processes to immediately get them in a mental health court, or to raise competency if that's an issue as well. Sorry, I probably should have let you answer this.
No, I agree with that answer.
I have a question. So much of mental health court depends on finding a provider who's willing to give treatment to an individual and staying on that treatment plan. How do you navigate the fact that court systems are inherently biased against certain individuals, like people of color, who may have trouble finding a culturally competent mental health care provider? I'll give you an example of a young man I know who was telling his young, I think 20-something therapist, white woman, about being afraid because he was being followed. And she put down in her notes, oh, delusions, paranoia. When what he was describing as a young Black man shopping in an upscale store was racial profiling. And how would you address that in your courtroom? And are you even allowed to address that? So I'll start with
Okay.
So being a person of color, I recognize and understand that, sometimes there are issues that people of color experience that others are unaware of, or just they're oblivious to it. And I think, when people say that this is an issue or whatever have you, and someone may just assume that they don't know what they're talking about or they're delusional is problematic. I think looking at, as I said, Seattle is so resource rich, and I've seen so many different providers or entities that have maybe more of a cultural competence for maybe Black and Brown individuals or Native individuals. And again, I think we just don't do a good job of really building out a proper infrastructure to say, and again, it's not it's not a one size fits all. You know, some people are fine with in certain places, but some people may want, you know, I have friends who, if they're going to a counselor, they want a Black counselor because there are things that people, you don't necessarily have to explain. It comes with the territory sometimes. So I think we need to be cognizant of that. And and as I said, in Seattle, I've seen that there's so many providers, some who actually do specify that they work with, you know, young Black men, or specifically that they work with, you know, single moms or whatever have you. So I think we can do that. I think we can provide that service. Again, I think it's just about building out that infrastructure and creating a collaborative environment that people can be a part of the system. Mhm.
And Judge Shadid.
Culturally competent care in Seattle is one of the biggest hurdles I think that we're facing. Although there are certain organizations that I think are amazing, among them I would count Asian Counseling and Referral Services. But, you know, they've been heavily lifting the entire, you know, Asian Pacific Islander community for a long time, and they're overwhelmed. A big hole, I think, in culturally competent processing is with East African communities, many of which have suffered through ethnic cleansing and war and civil war. Another huge hole is trans people, and we're seeing a lot of trans people being cycled through the jail. And although the jail has gotten much better with trans people, the treatment out there with culturally competent care has not. You know, you have a lot of people who will lump, you know, African Americans and East African immigrants together. You know, they don't know the difference. So all of these things are very frustrating. And as a judge, you know, I can't create culturally competent care, but what we've been finding is that there are certain organizations like the Ethiopian Community Center who will start groups. And, you know, it won't necessarily have a professional psychologist, but it is a place where people can gather and they can talk about their issues. And that connection to community by itself has a vast therapeutic potential. And so we are willing to substitute certain things if we need to, if people are unable to find the culturally competent care that they need in order to get better. And that's part of the whole harm reduction that I've been talking about.
And I have a quick, I was just gonna piggyback just in regards to like the East African community that, you know, they have their elders and they have people, you know, it may not look like the Western way to do things, but for an individual, an immigrant to this country who's used to, you know, how the elders come in and they sit down and they talk and, you know, that's how things are worked out. So I definitely think we can be more inclusive from a court perspective to bring the elders to court. Let's like be more inclusive and open to really allow more flavor in how we do things.
There was one other question, which was, and I've lost my copy of it, but there's a very large backlog of cases in the Seattle Municipal Court. How can the court address that?
You want me to go first?
Yes.
Oh. Well, I think that the pandemic had many bad things like the backlog, but also many good things where we increased a lot of access to services in the court. We went virtual, we allowed people to call in. There was a 3-month period though, where I was literally only seeing people who were being booked in jail on sorts of violent type crimes in mental health court. And we had to work really, really hard to make sure that those people got their procedural due process. It was very much a triage at the time. And then, you know, the prosecution, the city attorney's office had stopped filing a lot of cases because we couldn't process them. And then they came later. And frankly, we are making very good progress, slow but steady progress. The city attorney has been working with us. The court has been, you know, expanding its capacity. Just the other day, I expanded the size of my calendars. I regularly overset my calendars to my clerk's dismay in order to get more cases on there. But, you know, we're there to serve the public, and, you know, sometimes we just have to work harder in order to clear the backlog, and that's what we're going to do. We're just going to keep our nose to the grindstone.
Yeah, well, with mental health court, it's Monday through Friday already. So, you know, it's for the court to really try and increase capacity. It would, you know, the only place I can see for mental health court specifically would maybe to do, you know, an afternoon on a Friday mental health court calendar, even though there's already a mental health court calendar on Friday at 10. So I think, you know, as Judge Shadid already stated, you know, increasing the calendar size, but for mental health court, I think you need to have a smaller number because it is more therapeutic and you may spend more time on each individual case. So, you know, making the calendar much bigger may serve a disservice because you still want that intensive, you know, one-on-one with the court and the individual to really talk through how they're doing. But maybe, you know, slowly but surely adding an additional case here and there on each calendar, and maybe, as I said, adding a Friday afternoon calendar for capacity. But it is going to take some time to get through the backlog, most definitely.
But one thing I want to be clear about, though, is we have cleared out any person who's sitting in jail. We did that all the way through. So people were not being held in jail longer. We prioritized those. Right? I just want to be very clear to the public about that.
I have a question. So this year, the city attorney's office created a high utilizers list of people that were no longer eligible for community court. This included several people who were True Blood case members, and over half who were waiting for competency hearings. Is it, in either of your opinions, ever acceptable to create a list of people who are no longer eligible for court-assisted treatment? And how would you go forward if you determined someone was not responding to the court in a way that would require jail?
I'm going to ask you to define the True Blood.
The True Blood settlement was reached from several class action members because individuals with mental illness were being held in jails for weeks or months at a time without receiving any form of treatment. It's currently an issue in the city and the state because we are dealing with that kind of backlog in the jails again, where people are not being able to get their competency treatment quickly enough.
Okay. Well,
but the main question out of all that context is it ever appropriate to create this kind of list for mental health court, or is it appropriate to remove services that could be obtained through the courts or may only be obtainable through the courts for any individual with a mental health condition?
okay. Okay. So I guess to be clear, the high utilizer initiative was specifically for community court,
Yes.
not mental health court.
Right. And I would love to hear also, if we have time, a little bit about the difference between the two.
Okay. So community court is for the description is that it's to serve lower level offenses. So I believe there's approximately like 22 types of cases that can go into community court. So if an individual has opted into mental health court, even if they have community court as cases, I believe they may go to mental health court. However, people may opt out, and if a mental health individual opts out of mental health court and has a community court eligible case, which is potentially theft, criminal trespass in the first and second degree, property destruction, vehicle filing, those are some of the cases, the types of charges that can go into community court. So the city attorney, and not speaking on her behalf, however, my understanding is that, and from my review of some of the community court cases, the issue was that individuals had multiple cases going into community court. So it wasn't about that an individual wouldn't be able to have services or access services. The thought was that individuals who continue to commit crime and have multiple cases at one time maybe should not be eligible for community court because community court, the model as is, if you are committing a theft, for instance, the court will only take 14 days of jurisdiction, meaning the case will be open for 14 days. You have to do a social service contact. You have 6 hours of community service hours that you have to do. And you may have to do like a life skills course or maybe another service, but those have to be done within 14 days. And if you finish those requirements in those 14 days, let's say if you have 5, 6 cases, all those cases get to be dismissed because you have completed all of that. The city attorney reviewed a number of cases and saw that individuals were still having multiple cases, because you can go into community court, I believe, at least 4 times. However, there's no maximum amount of cases one can have at one time. So the high utilizer initiative was born out of the fact that I believe the city attorney was requesting individuals to be screened out of community court because the thought was that they were continuing to commit multiple crimes while in community court. I believe that request was denied. So then the high utilizer initiative came about, and it automatically takes those individuals out because they have X amount of cases. And the thought was that those individuals may need a bit more intensive care rather than just immediately dismissing their case.
All right, I gave you an extra minute.
Okay.
For this complex question.
Mhm.
And I'm going to have to Judge Shadid, and then I might ask you to clarify statements based on whatever Judge said.
Got it.
The high utilizer initiative was deeply flawed from the beginning. It was based upon inaccurate assumptions and inaccurate understandings of the community court. When the city attorney, the new regime came in, they insisted that their flawed understanding was the truth. And it was very difficult to explain to them that they did not understand what was actually happening. So they, first of all, scooped up all of these people, high utilizers, and they didn't vet the list at all. And so what happened was over 50% of them were true blood class members, meaning they had not received, or that they had been found unable to proceed in the past. It was disproportionately affecting BIPOC people, Black, Indigenous, people of color. And the city attorney's contention, which was absolutely false, it was a flat out lie. I have to say that because I told them repeatedly what the truth was, and they repeated the lie over and over, is that the people who were assigned to community court had failed community court who were on the high utilizer list. And that was absolutely false. And this lie got repeated in the press over and over again. What had happened is they didn't show up for court. They had never participated in community court. The one high utilizer who had graduated from the court hasn't had a criminal conviction 2 years later. So, this whole thing was very frustrating to me because I was trying to explain to a new city attorney what the facts were, and the new city attorney was telling me what they perceived the truth to be, which was not the truth. So I fought it, and unfortunately, the city attorney decided to go to the press to fight it. But the short answer is, if you're going to make a list, especially one where you are stigmatizing an entire population by calling them high utilizers, it needs to be individually vetted. You need to figure out what these people's barriers are and how to solve them. The only solution the city attorney has offered to date is to hold those people in 20 jail beds that they have reserved for what they call high utilizers. That is not a solution. They have refused categorically to work with the court, either mental health court, community court, or the consolidated calendar, to help these people on an individual basis. I will keep trying to work with them. I will keep trying to explain where their false assumptions are, but it has been a frustrating process. And I guess that's all I have to say.
All right, I'm going to give you 2 minutes for rebuttal.
Okay. So the city attorney looked at data that's provided in the court system. I've looked at data provided on the court site. Anyone can go on the court site and look up cases and look up the court calendar to see what is happening. That is what the city attorney did in regards to looking to see the activity of participants in community court. So I too have looked through some of those cases, and if someone has a community court offer and doesn't show up to court, not one, but two, not three, but 4 times there's been an order to appear or failure to appear, and that person has not participated at all, that is a community court offer that was made that is just not, the person is not participating. So that is some of the data that is out there, that the participants don't come to court. So that's one thing. The city attorney's job, or one of the city attorney's job, is to balance public safety. And if individuals are committing crimes and are not being held accountable at all, but continue to commit crimes, the city attorney's job is to work on that. Judge Shadid brought up the 20 jail beds. The city attorney doesn't keep people in jail. The city attorney will act. The city attorney makes requests, will ask that the court impose bail, but ultimately the court is who imposes bail and who sets conditions of release. So we all have a different role in part of this process, but the city attorney's job is to look out for community safety. And if they see that there's something happening that is falling very short, then it is their prerogative to try and figure out how can they make the system better for the community.
It's their responsibility to tell the truth. And that has been a problem. And welcome to the crux of our campaigns against each other. This is exactly what's been going on from the very beginning, where misinformation about the so-called high utilizer list has been used against me in false ways in order to try to paint community court as something that it is not. And it is very frustrating because this is a low information election and everything that's printed is taken as the truth, and it is not the truth.
And just if I could follow up for our community members, if someone is unable to pursue community court, would they still be eligible for mental health court?
Yes. If they have qualified diagnosis.
All right, I'm going to say this is the last question. If there's any questions, because and 2 minutes per candidate, because we got to be out of there by 30 minutes, 8:17. Vince?
No more questions in the chat.
Over the past 8 years, I've tried to deliver on my promises. I came to this court as a reformer. I came to this court trying to find better ways of doing things in the criminal legal system, where instead of being a force for negativity, we were a force for positive things. I came with very specific ideas about creating a new community court, working better with the community, breaking down silos, expanding mental health court, and just generally coming to the bench with a more empathetic understanding of the traumatic barriers that many people face in the court system have. I also wanted to address the severe disproportionality for BIPOC people in the criminal legal system. And I wanted to create programs that could address those issues as well. The programs that I've created, from my early years with the heroin task force to my later years with community court and mental health court, have done just that. We have helped many people. Community court, for instance, the people who graduate community court, 80% of them do not commit new crimes 2 years later. I'm very proud of that number. In mental health court, we have similar lack of repeat offenses. My entire career has been based on working with legitimate partners, both in the community and in the system, to try to get things done. But the work isn't complete. There is so much more to do. And I believe my voice and my experience make me the best candidate to continue for 4 years and to continue these changes that I've already begun.
Thank you. So none of us are happy with the condition of Seattle right now. And in fact, many are really disappointed in the direction that the city's going. I am running for Seattle Municipal Court because I think I can make a difference. I've worked in the city for the last 12 years, And I've worked behind the scenes and I have seen a lot of things. I worked as a prosecutor in the criminal division. I worked as a civil attorney. And even in my role now, where I advise the mayor's office and the police department, I see the holes. And I see that we definitely have the ability and the resources, but we just don't have the partnership and the collaboration. In my current job, I can't do anything unless I'm partnering or collaborating with other people. And I believe I am the best person for this job because I understand how to collaborate. I understand how to partner. I understand how to build systems to really better provide the systems that we need to really help people. The court system is not going to single-handedly solve all the issues affecting our communities. However, it is a part of the recipe for building a better city. One with like honest and just courts working and partnering together to help community. So that is why I'm running. The community needs to be a part of this solution. And I believe the court system has been siloed for far too long, and we need to break out of that silo to better serve the victims, the offenders, and the community.
Thank you so much. I think we've run out of time on our agenda. We've got to be out of here in 9 minutes. So thank you so much.
Thank you guys. This was a great forum. Really appreciate it.
Thank you both for coming out on such a smoky night. I know that my eyes were burning and drying over here, and hopefully the smoky border will be clear by Friday.
I thought we were going to get away without talking about high
Good night.
That's always a touchy subject. So.
Thank you, everybody. And there will be a recording available as well. Have a good night, y'all.